Boom. Hey, I should be bigger than that. Okay, here we go. Boom. The bigger boom. How's everyone doing? I hope everyone's had a at least tolerable Christmas. Um, I know some people are struggling to get through, and you made it. You've made it if you got to this far. So anyway, yeah. Hope everyone's doing well. I just want to address one comment I got via email. Um, because somebody sent me a comment via email and they were very upset. So the comment I got via email was somebody saying, "How dare you betray Rob by running a Friday show?" Um, and the answer is Rob knows. Like I told Rob and I got his permission and is okay on all of this. So there is no Rob betrayal. There's not a Rob is busy. He's got trial stuff. He's got all sorts of life stuff, and he doesn't anticipate being back streaming until February. So, yeah, I was like, "Hey, do you mind if I run things on Friday until then?" He's like, "Please, please do." So, yeah, so for the people who are like, "Hey, is this drama?" It is not drama. It is the opposite of drama. So I just thought it was a little funny because the person who sent me an email was very, very upset, and I was like, I don't know what to tell you, folks. Like, this is not war. This is this is friendly. So yeah. All right. Yeah. Somebody says Rob who? Normally the Friday night slot has been Rob, Law and Lumber, and yeah, I'm just running some things at the time. That's a rude email in my opinion. They're just really concerned about whether or not like I'm treating Rob fairly or whatever. So I get it. Like I'm not angry or anything like that. I just thought it was kind of funny because it's like, what, are you taking Rob's spot? Like you're just moving in on his, and I'm like, no, we're friends. Also, I pulled the tie out. Mrs. Runkle washed my tie, or so. Yeah, and then people were like, "Where's the tie?" Which I guess wasn't helping. So yeah, so let's see what else for housekeeping. I had a lot of people who were wondering what was it that I got Mrs. Runkle for Christmas, because I can oh yeah, we were able to snorkel. The snorkeling was lovely. So there were some questions about what I got Mrs. Runkle, and I will admit those questions are my fault because I intentionally wrapped her gift in a way that would lead to questions, I guess. So let me show you the wrapping job I did on Mrs. Runkle's gift. And you guys can try to guess if like what you think this is. Now, so here is Mrs. Runkle's gift wrapped. Now she already knew what this was. She already knew, but I wrapped it like this to perplex and confound her parents and be like, "So, do you know what this is?" Did anyone get it right on Twitter? Nobody on Twitter got it right. Nobody on Twitter got this one right. I see. I am perplexed and confounded. Yes. And yes, Rob and Ian met sleeping on cement, waiting in line to watch the jury during Depp versus Heard in Virginia courthouse. Yep. So what this is This is several lipsticks, and I taped them end to end and end to side in a way to make it an unusual shape. Because, yeah. Um, now you might be wondering, why did you get her lipstick? Well, because she suggested it, and that's partially because the big gift is going to be a combined birthday Christmas gift. So we're gonna do that later on, and she already knows what I'm planning for that. I'm gonna try to get that try to get that going, and it should be pretty cool if I successfully make it happen. So yeah. Now I also set a goal. The goal is my mom got me something for Christmas that I think you guys would be highly amused by, and I think she got it in order to highly amuse you folks. So I will show that to you if we hit the goal, because yeah, it's highly entertaining. And I was like, all right, I guess that's what we're doing. So yeah. I thought it was pretty entertaining there. So yeah. Okay. So otherwise we are what is it? Just engaging in some sidebar review. We have the sidebars from the Karen Reed first trial have been revealed or been released, or they're coming out. I don't think we have all of them yet, but they're coming out. Does mom watch the stream? She does. My mom does watch the channel, and I know this because I know this because sometimes she mentions things that I'm there. Please tell Mama Runkle she's awesome. She knows. Did Mrs. Runkle tell you what shades of lipstick? Not really, no. She said lipstick, and I was like, okay. So I got lipstick shades that I thought would be good, and yeah, that's the plan. Okay, so we are on day 11. My family got me in order new bed sheets and pillows, new shirts, and underwear / socks. Somehow I suspect my family thinks I live like a gremlin. New socks are one of those things where as a kid I thought socks were the worst gift, and now as an adult I have been given like good new socks before, and I was like, this is the best of my presents, is the super comfy socks. So yeah, really nice socks can be something special. So but don't get them for kids. I don't have any kids, but I have a niece and a nephew, and neither of them got socks. It's not how we're gonna roll there, because I feel like they would have opinions if I got them socks, and those opinions would be, this guy sucks. Okay, so here we go. Let's pull this up. I don't think she's here right now. I haven't seen her in the chat, but she does watch. I think she usually watches like after the fact and so forth. But all right. Now we have a lower number of people here today, which is not surprising because quite frankly, it's Christmas Eve. So I'm not surprised by that at all, but do hit the like button on the stream. And yeah. Okay. So now we've been going through the sidebars and going through them sort of in depth. And part of the reason for that is so that we can we can see sort of the good and the bad, right? Because I would, much as it would be something to show you only the moments that really piss you off, like the moments where Judge Canone is being unreasonable. I feel like it's important to show the moments when she wasn't, and also the moments as well when, for instance, Lally is not being unreasonable. Because last time we saw some moments where Lolly was being entirely reasonable, entirely, friendly, and yeah. So I, I think it's important to cover that as well. So it does mean it's going to be a little longer, and that some of the sidebars are going to be ones where it's like, okay, why? Because nothing's happening here. But I think it's important to have the perspective. So that's just a bit of explanation. All right. So this is day 11. I think that's where we left off. And here we go. So they come back and they call the jury back in. And they say, I'm going to ask you if you were able to refrain from seeing or reading or hearing anything about this case since we left the other day. And then they have a sidebar, which is juror issues. And the juror issue here, I am really curious about. Like this, yeah, there was that. Christmas Eve. It's Boxing Day. Christmas Eve, Boxing Day. Yeah, I suck. I'm tired. So they have they start off with a juror issue. And the juror issue, of course, is redacted because it's a juror issue, but it's extensive. Like it is a whole page, 2 whole pages, 3 whole pages. It's about 4 pages of stuff, right? So something happened with the jury on that day that required some extensive discussion. And we don't get to know what it is. And I'm super curious about what this jury issue was, because it gets some substantial attention and something happened. And yeah. Question, do the sidebars get curated before release? They've redacted some of them. But they've only redacted for juror issues or jury anything. And question, do the sidebars get curated before release? Also, did you hear about the sheep who became a lawyer? He was fond of sidebars. Oh, that's awful, and I love it. Okay. So here we skip ahead a little bit, and there is a so there's a sidebar here, and the Lolly is going, sir, I'm going to direct your attention to what's currently marked as Exhibit 7, 10, 11, 12, 13, and so on. Would you review those to yourself and look up when you're finished? And then Lolly says, Your Honor, may we approach? And so he says, Your Honor, what I'd like to do, just to make Ms. Gilman's life a little bit easier, is if I could publish them to the jury, referring to the numbers that are currently on them, and then have them marked as the next subsequent exhibits. Court says, all right, so you want to publish them first and then we'll mark them? He says, just so I can refer to them as exhibit blank. Court says, is there any objection to doing that? Mr. Jackson says, no. And the clerk says, can we all just stay here for a second? For the record, FTR is down right now. The official court reporter obviously is here. Tori and I are working on FTR, but it's not recording as of right this second. Court says, okay. Clerk says, you can see that the clock is frozen. All right, thank you. And so then they go, sidebar conference concludes, and the clerk says, Mr. Lolly, hold on for a second, and they go back to sidebar. So do you need to call them anything from Ms. Gilman? Can you just go over there, and Madam Court Reporter is concerned that the record is going to say whatever you just call them, and then we're going to, okay, I agree with her. I think it'll be confusing. Okay, yes. So just take a minute and go point out which ones she has to put up or something. Sure, I can do that. Yes, whatever works best. Thank you. So this is just basic housekeeping, and it's just everybody behaving well. nobody, this is partially caused by Judge Canone like re-exhibiting everything the night before, going like, oh, the clerk doesn't want you referring to like her by name. Don't call her Nancy. But let's rejig all of the court files. And but yeah, they're just trying to work things out. It's nothing momentous here, but it just shows you kind of the business of lawyering, which I think is worth seeing. All right. So then they have Mr. Lally says, showing you a disc. Do you recognize that? I don't recognize it. I haven't seen this disc before. Your Honor, may we approach? So here is the fun thing. This is when they're showing a witness like a disc, and he's like, the witness is like, I have never seen this disc before, because it's not the disc that the witness ever dealt with. It's a disc with videos, right? So he's like, yeah. So this is just a bit of a bizarre thing, but he goes and has a sidebar conference. Says, so, Your Honor, in the interest of time, I can tell the court that the disc contains the 2 videos we were just talking about. I would like to have it marked as an exhibit before I play it for the witness, who can authenticate it because he sent it. If there's any issue with that, Mr. Jackson says, no, from a procedural standpoint, I don't care. I just want to make sure I understand that the disc contains the 2 videos. Mr. Lally says, I think it's more than 2. Mr. Jackson, you think it's more than 2? Well, they're broken up into, I mean, it's all sort of the same footage, but it's broken up into small snippets. Yes. I don't have any problem with it. Court says, all right. While we're on exhibits, he testified to the first photograph. By the way, this is Jackson being solid. This is Jackson being a very reasonable person, because Lally here actually has a problem. And the problem is that he's got these 2 videos and he wants to authenticate this disc. But the disc itself is something that he hasn't seen before, right? It's not it's something that's new. It's something that's different. It's something that they just now have gotten. So the issue that we run into here is that he might actually have a difficult time getting this disc in, because the witness is like, I can't authenticate this particular disc because it's a copy, right? And I haven't seen this particular thing. Jackson, if he wanted to be a jerk, if he wanted to be a dick about this, could say, well, the witness isn't authenticating it, so that's a Lally problem. Instead, he's being reasonable. He's saying, look, it's got the videos on it. I accept his representation that that's all that's on it. I'm willing to allow it in because we know what's in there. So it's yeah. It's going to be an interesting thing. It's going to be quite fascinating as to how this how this goes. But we're actually, like, I love that we get to see people being reasonable. I like that we get to see them going, we're going to work this all out. All right. So he testified to the first photograph being photo number 20, and 20 is Becker's report from the other day. So did you inadvertently give him what had been previously marked 20 in that pile just now without any sticker on it? Because these photos, Mr. Lally says, I may have. Court says, I have it. We started at 21. Is that right, Tori? Is that right, Tori? Remember, last time we went over Judge Canone losing her mind because how dare you refer to a witness by their first name And now she's going, is that right, Tony? So, or sorry, Tori, not Tony. So, you know, there's a little bit of a double standard here. Just so if there's one in there with a sticker on it, that's 20. Yes, we're removed. He indicated what all the others were. Mr. Lawley says okay. He said there were 2 of them, so it's probably one of those anyway. It's probably a duplicate. If you all want to look at that at a break and figure that out, you need to do that. Mr. Lawley says okay. So you can go ahead and put that in. Mr. Lawley says okay. So what we're seeing here is that Judge Canone's decision to renumber all of the exhibits at the last minute is having persistent fallout. It's causing shenanigans. So then we go, and there's another sidebar just afterwards as they're trying to enter another exhibit. And Mr. Lawley says, I believe what happened was Madam Court Reporter inadvertently marked the first photograph in the set today as 20. So now we have 2 20s. So before we go on, and the court says, no, she did not. That has 429. That is yours. And he says, oh, I'm sorry. Court says, this is where we started today in marking them. That's probably a duplicate. He says, I think you said we had 13, but we actually marked, that might just be the last one. I just don't want to keep marking exhibits and further compound the problem. That's the only reason I asked to. And the court says, these all have today's dates on them. That was pre-marked by you as 20. So you can, and Ms. McLaughlin, do we already have a 20? Court says, we do have a 20. It's Becker's report. Ms. McLaughlin, can we amend this to be the last sequential order exhibit? Court says, how about we do it as 20A because he has referenced it as 20. Now we're doing 20A. Okay. And I see JC says, longtime follower and recently got a new job allowing me to join and contribute to your endeavors. Thank you, JC, and that is awesome. Also sent you an email on the Kimberly Sullivan case with all supporting documents in case you want to look at it. I will have a look at it. I am behind because I have so much stuff that happened while I was away in Ecuador. And so, yeah, I've got a whole bunch of stuff I got to cover, but yeah. So the court says, at least it will have that number that corresponded with what the jurors saw. Okay. Is there an objection to that? Mr. Jackson's like, nope, not getting into this mess. Court says, we'll do that. Hand that to Madam Court Reporter to be marked. And really the marking on this is not the time to fight. I hereby decree when speaking about 20A, you call it 20 alpha. Fair. What was the temperature in Galapagos? Like 24, 25 Celsius? It was quite nice. A little warmer than I'd like, but yeah. So, but I mean, quite pleasant, quite sunny. Yeah. So, Mr. Lally, Your Honor, with the court's permission, may I publish what has now been marked as, I believe, Exhibit 20 Alpha? 20, I'm sorry, the last exhibit, the disc, if I could publish that to the jury. The court says yes. Ms. Gilman, if you could just pause it right there, whereupon the video is played and paused. All right. So, lots of chaos, lots of shenanigans result from all of this. All right, jumping ahead to the next sidebar. Next sidebar. All right. So, what is it? They have, I told him Detective Sergeant Lank was working. And as far as what, if anything, was that call in reference to, if you know? He stated he was driving in the area of 34 Fairview because of the warm weather and the warm rain in the last couple of days. And what, if anything, did he indicate to you that he saw? And Mr. Jackson says, objection. Court replies, sustained. I'm going to see you at sidebar. The objection is clearly hearsay, right? This is a hearsay objection. And the court says, isn't this just a straight hearsay objection? Yes, it is. Obviously hearsay, right? So Mr. Jackson says, correct. Court says, so I understand that this might be the knowledge of the police officer, but haven't laid a foundation for that. Mr. Lally says, okay, really all I'm trying to establish this witness, with this witness, Your Honor, is that essentially there was, I trying not to get too much into it. It's just it's just more that he then directs Berkowitz to Lank. Lank recovers the items. That's all. Court says, so you've got Lank testifying? Correct. Did Lank give the item to this witness? No. So Lank photographs the item and leaves it in place until state police shows up. Sergeant Kenny is the one who comes and retrieves it. Court says, okay, yes, you're not going to do that. Mr. Lally says, no. All I want from him is to get from Berkowitz to Lank. That's all. Court says, and how do you get from Berkowitz to Lank with him? Because he is the one that indicates to Chief Berkowitz that Lank is the one who's working that day. So Court says, so you already have it? Mr. Lally says, exactly. Court says, okay, so we'll end it at that point. Mr. Lally says, yes, definitely. What Mr. Lally was trying to get in was not super momentous, but it is proper and reasonable for Jackson to go, no, you can't do this. This is hearsay, right? You can't, yeah. Would you explain laying a foundation for something this simple? I don't think this is something you can lay a foundation for. This is hearsay. This is just out. This is just no good. Somebody asked, does the jury hear sidebars? No, the jury does not hear the sidebars. If you are present in court, you know, when you watch the thing, they all go up and they all have that little huddle. It's all very quiet. At the Johnny Depp trial, you guys did not experience this because if you were watching from if you were watching on screen for the Johnny Depp trial, they muted the audio every time there was a sidebar, right? And the reason why they muted it was not to keep from hearing the sidebars. The reason why they muted it was because in court, they have a big speaker and the speaker blasts out white noise to cover up everything they're saying. So every time they went up for a sidebar in the Depp trial, it went and it was like ear destroying. It was really obnoxious. And so you couldn't hear any of the sidebars. And I was like, okay, I get it. It makes it easier because they don't have to move they don't have to move the jury out and any of that. But oh my God, it sucked to hear. So yeah, it was real loud. Like it was not quiet. It was loud white noise. So yeah. But anyway, that's to keep the jury from hearing it, because sometimes the stuff that might get said at sidebar is stuff that you don't want the jury hearing, right? So as an example, I had a client who we were dealing with a very minor charge, right? He was charged with like a theft, right? And this wasn't a jury trial. But if you were running this as a jury trial, we would absolutely have needed to have stuff outside of the presence of the jury that they couldn't hear, because one of the questions that we ended up with big objections about was that the Crown wanted to put this guy's criminal record to him for cross-examination. And I had an objection to the specifics of his criminal record because he was like a past sex offender, right? He had a conviction for a sex offense. And I'm going, this is not relevant to whether or not he's telling the truth about like stealing something. It's just hugely prejudicial. But if you were doing this in front of a jury, right? And this wasn't, because in Canada, we run like minor stuff, not with a jury. So it wasn't with a jury. But, can you imagine the jury sitting there and this guy's about to get up and testify? And they're like, okay, we need to have a discussion as to whether or not the jury is allowed to hear that this man is a sex offender. And the jury'd be like, okay, we're done. We're going to convict now, right? And it has nothing to do with the theft. It just has to do. So, you obviously can't have the jury hearing that, right? It's not at that point, there's no point to the objection, right? The whole question is whether or not the jury should hear the extremely prejudicial information that has no probative value. So, yeah. All right. So now we've got a little bit more, and this is on cross-examination. Were you aware that before you got to the location that Sergeant Lank had taken it upon himself to already make contact with the individuals in the house? Mr. Lally says, objection. And the court says, I'll see you at sidebar. So whereupon there was a sidebar conference as follows. Court says, what is the objection? So the court doesn't know. The Jackson's objection, the court knew. They were like, this is obviously hearsay, right? So now the court says, what is the objection? Mr. Lally says, first of all, knowledge of this witness, whether or not he knows what Lank knew or what Lank did prior to him getting there. Secondly, court says, is it in a report Lank wrote? I'm sorry. Is it in a report that Lank wrote that he would have known about? Mr. Jackson says, generally, yes. If he'd reviewed all the reports, he would know, this lieutenant would know as a supervisor that Sergeant Lank had a certain relationship or had a relationship with which he just testified to with the Alberts. Court says, I understand that, but your question was whether he knew what he'd done before he got there. Mr. Jackson says, correct. The only way that he would know that is if Lank had informed him. I've already interviewed these folks, and that's what I want to find out. Why did you task him to do something that had already been done? If he says, I didn't know, then I'll live with that. Court says, okay, or all right. So the question that was asked, you can ask. Mr. Jackson says, okay. And she says, I'm going to allow it. If you were to make like one of those Kewpie dolls of Judge Canone where you pull the string and then like it says a recorded voice, I'm going to allow it would be like the number one thing you would put on the Judge Canone doll because, but here she's given it to Jackson because during the trial, when we were watching the trial, it certainly seemed like all the I'm going to allow it seemed to be going in favor of, Lally. And here's one going for Jackson. So I think this is worth noting, right? Jackson wins this one. And Mr. Lally says, okay. Mr. Jackson says, thank you. And the sidebar conference concluded, and he goes back to the question. So Jackson wins this sidebar. And yeah, a lot of people, I was surprised to see that there were sidebars that they were winning because I thought that there was going to be a lot more sidebars that were going in for, in Lally's favor and so forth. So then we go and they have a break. There's the jury is escorted out and the sidebar conference begins with a juror issue, but it's a short juror issue. And I'm guessing it's not a big deal, right? They say, Mr. Jackson says, I appreciate that. The court says, so it takes about 10 minutes because they've got to go through another courtroom to do that. So you all have 10 minutes. I'm guessing the juror issue was something along the lines of they need to go and take a shit or something like that, right? They got to, or it's not a huge deal. So, that's their sidebar is basically something is up with the jury and it's not a big deal. Just scheduling, just whatever else. All right. On to sidebar at page 138, which I believe is also more scheduling things. So court says, okay. And while the sergeant is coming in, we'll see counsel about scheduling. So sidebar conference. All right. So we were off on how long things might take this morning. Does it make sense? So is Lank your next witness? Mr. Lally says, yes. How long do you expect this witness? It could be equal. Does it make sense to maybe after lunch or maybe to after lunch so this witness will go past lunch? I think so, yes. And there's no doubt. And your cross? He says, it's probably about the length of Mr. Jackson's, I would say. All right, so maybe we send the jury home early and do the voir dire of Lank when we finish with this witness. Okay. I mean, do you have a short witness in between? In between? No, but I think Lieutenant Ray, is relatively quick. All right, let's see what time it gets to be, but I'd like to do that voir dire today and have Lank on tomorrow rather than Mr. Lally says, sure, okay, that makes sense. Do a quick voir dire about it. Okay, thank you. And the sidebar concludes. Often this happens where, like, the court asks you to predict how long a jury is going to be, or how long a particular witness is going to be. And you're like, okay, it's not going to be long. And then suddenly they end up taking forever, right? Suddenly they end up taking a lot longer than expected. So I had one where a police officer that the Crown anticipated would probably be about 30 minutes between the two of us, right? Between their thing and mine. And the thing is I was not expecting this witness to be a long witness. I was expecting this witness to be a quick, I have 3 questions for them and then I'm done. But in testimony, I discovered that this witness had seen some things that I thought were really interesting. And so there was an issue with regards to a search. And this witness basically made some offhand comment about, how the search was done. And so suddenly this witness went from like a, 2-minute cross-examination to a 2-hour cross, because now I really wanted to get into what this witness saw and what was going on. And I just kept getting more and more information out of this witness. And the judge is like, Mr. Runkle, I thought you and the Crown said that this would be a short witness. And I'm like, I thought so too, Your Honor. Like, what do you want from me? Right? I didn't expect this. Like, this is nice for me. And so, it happens, right? And sometimes you get witnesses where you're just like, I don't want to do anything with this witness. It's going to be real short. Okay, now we're going to jump a fair bit ahead. We're going to hit the scroll wheel because they managed to go without sidebars for a little bit. All right. So, they've got here, what is it? And you're listed as Sergeant Sean Good or Goody. I can't remember if it's Good or whatever. That's you, correct? Uh-huh. Of the Canton Police. And you were assigned as the primary investigator in this reconstruction because I wrote the offense report from that day? ? And he says, well, I'm just asking you. I'm dealing with a state police report that lists you as the primary investigator with regards to the reconstruction. And Mr. Lally says, objection, Your Honor. May we approach? The court says, sustained. Sure. Why don't you all come up? Bring that, please. Why is she sustaining it when there was a sidebar, right? There's a sidebar request. So whereupon there was a sidebar conference as follows. Court says, can I see it, Mr. Yannetti? Sure, of course. That's the beginning of the report, and that's the paragraph. Who wrote this report? Mr. Yannetti says, not Sergeant Good. Somebody else. Right, I know from state police, but why don't you take that and tell me the author while I read this? Mr. Lally says, it's Trooper Paul, Your Honor. Yes, Trooper Paul. Okay, is he on your witness list? Mr. Lally says, yes. Now, we all remember Trooper Paul. Trooper Paul is very accomplished because he took like a weekend course in which he was vaguely made aware of math. Trooper Paul did not do well on the stand. So this is a little bit of foreshadowing here. The court says, okay, so some of what causes difficulty is asking questions of the wrong witness. Mr. Yannetti says, uh-huh. Court says, so he didn't adopt any of this, right? Mr. Lally says, that's really not what the report says, Your Honor. He had nothing to do with the reconstruction. In any reconstruction report, they're going to list who the primary investigator is with the involved department. So whoever they spoke to on scene or whoever wrote this OF report is going to be listed in the recon report as the primary investigator or as a primary investigator. That doesn't mean he had anything to do with the reconstruction. Mr. Yannetti says, I can ask a couple of, I didn't know that, but court says, what was that? Mr. Lally says, I would assume Mr. Yannetti knows this. Mr. Yannetti says, I did not. I'll ask another couple of questions just to get that out of it, and I'll move on. Court says, okay. Mr. Lally says, thank you. So this is a regional difference, I think. This is some of how Canton does business. And yeah, it's Lolly's going, I'd assume Yannetti would know this. He's like, how would I know this? I'm not from here. I don't even go to this school. I should start another goal. What should the goal be? All right, I'm going to start with that Boxing Day story. I feel like some of you don't know what Boxing Day is. So, oh yeah, Yannetti is from there. Jackson isn't, right. Yeah, he's just like, I don't know this. That's fine. Lally is trying to do a bit of dunking on him over that. So it's kind of jerkish, but oh well. All right. So skipping ahead. All right. So questions. So do these both appear to be fair and accurate representations of the dash cams that were going on at the time? Yes. Mr. Yannetti says, I would offer that, Your Honor. Court says, okay, I'd like to see counsel at sidebar for just 1 second. So whereupon there's a sidebar conference as follows. Okay, if there is no objection to it, I'm going to let it in. I only have one question. Mr. Yannetti, So it's been altered in that it says, as read, Officer Saraf dash cam and Officer Good dash cam. Their own dash cams don't say that. They're just numbers. Mr. Yannetti says, true. Court says, and it's 2 of them spliced together or put together. Are there any other alterations to this? He says, no, it's just only the wording. That's it. Mr. Jackson says, the labeling and the synchronization. That's it. Mr. Yannetti says, yes, that's it. Court says, all right. Thank you. Court says, that will be admitted as Exhibit 16. So whereupon the sidebar conference concluded. What she's trying to make sure, you are generally going to be extremely limited as to editing you can make. Any more trip pictures or stories to share? I have so many pictures and stories and so forth. So I can do that. We'll see how this goal goes. So yeah. All right. Carrying on. So going on to last one of the day, and then we will I'll show you the gift because and go through some super chats, and then we'll move on. So all right, date and time reported is listed as January 29th of 2022 at 6:08, correct? Which would be in military time, 6:08 a.m., correct? So all right, then the report date and time is listed as January 29th of 2022. Mr. Lally says, objection, Your Honor. All right, so why don't we come to sidebar now? I'm sorry, I'm going to take that from you. Witness says, sure. And the court says, the objection? Mr. Lally says, I don't understand the relevance or the point of this. If he's just going to read the entire report word for word, or Mr. Yannetti says, no. Court says, I just want to say the reason I wanted you to come to sidebar. Mr. Lally says, sure. Court says, if the Commonwealth tried to put in a police report, I would shoot them right down. Mr. Yannetti said, I understand. So what are we doing with the screen, and why are you reading to him? Mr. Yannetti says, okay, so the portion that I just read, it's essentially all I'm going to ask him. Court says, what page are you on? Because he says, it's on the first page. It shows the incident number, the call number, date and time report, report date, and time and reporting officer. That's it. That's all I was going to read from there, and then I was going to reference the photo. Where I'm going with this, Your Honor, is identical information that I'll have him corroborate the altered and changed. We've blocked out any, compromising information. I'm not seeking any other portion of the report, but I'd like to show the jury that, and then a close-up of that photo, show the jury this, and then a close-up of that photo. Court says, what is that? He says, this actually shows a piece of taillight that was not in the original photo. It's a completely different photo. Court says, okay, have you shown him this yet? Yannetti says he's not seen this yet. Court says, all right, is there an objection to just continuing here and showing him that one photo? Mr. Lally says, I have no objection to showing a photo to the witness, but I don't want a photo going on the screen. So show it to the witness, but don't show it to the jury. Don't let the jury see this extra piece of tail light. Court says, all right, so you're going to have to show him this. It's late in the day. How much longer do you have with him? He says, I mean, I think I might be able to finish by 4. No, apparently not. I don't have that much more. Probably more than 15 minutes. Court says, okay, so why don't we bring him back tomorrow, deal with this issue, all right? He's going to have to look at it. I'd like these marked. I'd like to have that voir dire of Lank today. He's here, right? Mr. Lally says, I believe so. He was. And Mr. Yannetti says, my concern, Your Honor, from a strategic standing and also with regards to sequestration, I have now shown my cards. Court says, I don't think you have because it wasn't at all clear to me what you were doing. And he says, I get that. My point is I don't want the Commonwealth to be revealing to the witness where I'm going with this. Court says, he won't. Mr. Yannetti says, okay, that's all. Now, I don't know if I trust the Commonwealth on all of this. But yeah. Rob is busy. Rob is getting married. If Rob was getting married, I would not be here right now. I would be at the wedding. When Rob is getting married, I anticipate that I'll be there. So yeah, it's yeah. All right. Let's continue on. Oh yes. I will tell a little bit. I will tell a little sort of side story here. So a judge, she's now a justice of the Court of King's Bench, but at the time she was a provincial court judge. And I was appearing in front of her. She's one of my favorite judges. She has never gone easy on me. But she is one of my favorite judges because she is, she's no bullshit. She's fair to defense and to Crown. And that means that she's kind of harsh on both of them. But she is lovely to appear in front of. And I was conducting a cross-examination. And in the middle of my cross-examination, I was sitting there and my phone rang. And she does not like it when your phone rings in court. She does not like it at all. But I'm like, I apologize, Your Honor. My phone rang and she said, Mr. Runkle, it's interrupting your cross-examination. But if your phone had interrupted your friend's cross-examination, we would be having a very different conversation right now. And I'm like, I understand, Your Honor. I'm turning it off. It's all good. It's off. And the point of all of this is that the judge quite reasonably was like, you cannot interrupt the opposing side's cross. That is not okay. And him having his cross-examination interrupted like this is a bit of a big deal. And especially, like, the worst thing that happens is when you're sitting there and you go, you've got a witness, you've got them on the ropes, you're about to hammer them, and then the court is like, and we're going to take an hour-long break. And you come back after that hour-long break, and suddenly the witness has thought of all sorts of things to counter your line of questioning, right? Suddenly the witness, because they can't come up with the good lie when you've got them on the stand and you're making them talk. You make them keep talking so that they can't think of bullshit. They can't think of a lie, right? You keep them answering. You keep them on the ropes. You keep them going. Because if you give them a break, then they sit there and they think of the explanations. They think of the defenses. They think of all the things. And then your cross is blown. So, yeah. So the court says, otherwise, I don't know when we'll get that voir dire in. I think that's important. Mr. Unetti says, I understand. Court says, so does this seem like a good place to end then with him? And he says, that's fine, Your Honor. Yes, we can do that. All right, because you're going to have to show him that before, and then they conclude the sidebar. So he gets an interruption that he didn't want, and he's not super happy about it. So, yeah. What is it? Did I miss Runkle wishing Turtle Boy a happy birthday in Canadian tradition? It's Turtle Boy's birthday? Happy birthday, I guess. I didn't know it was his birthday. So, all right. So let's cover super chats, and then I owe you showing what my mom got me. A wild Runkle has appeared. Just what I needed tonight. Had the rear differential in my car go on vacation Christmas Eve. Car goes forward, but no reverse. Ooh, that's brutal. I'm sorry. Sandy, thank you for 20 gifted memberships. I got a thing for this. It is the thing. And Donnie, not Wahlberg, happy holidays. Thank you so much. P, why not? Thanks for a goal. Now take my money. Okay. Won't know if it's a $400 fix or $2,000 fix for 2 weeks because holidays plus shop moved locations on top of knee surgery. Definitely needed the surprise Runkle stream. I am really sorry to hear that, and I hope it's the 400, not the 2,000. Brentwood Cheek says, thanks for babysitting us. Thank you. Vez says, 39 months of fun. Thanks to you all. We gotta work things out on scheduling and so forth. So, Mary Matilda May, must see what Mama Runkle got for you. You're going to be amused. Brentwood Chic, and we didn't want to take naps. Now love naps. Yes, adulthood is about loving naps. Crab 1791 says, Merry Christmas. Thank you. Tracution, Merry Christmas. Yay for Galapagos for you and wifey. It was, so the Galapagos trip was because it was my wife's bucket list trip. She has wanted to, she has wanted to go to the Galapagos since she was a tiny little kid. Since she was a little baby, like little tiny Mrs. Runkle, before I knew her. And she's wanted to go. And it's like, let's make it happen. Let's go. She's like, can we? I'm like, yeah, we can. Let's do it. So yeah. Joy W says, here for the sidebars and to find out what gift you got from Mama Runkle. Oh, you're going to laugh. KRD says, question, do the sidebars get curated before release? Oh, we covered this one. Thank you, KRD. JC Music Man, thank you for becoming a member. Much appreciated. Jessica Pichardo, too. Thank you so much. Emily Ahrens, thanks for reading the sidebars. I had so many people going, are you going to read the sidebars? And I was like, all right, we'll do the sidebar. Unbalanced Equation, thank you so much for the YouTube membership. I can tell you quadratic equations I did not enjoy. Just me mostly. Merry Christmas. Merry Christmas. Random unbreaded commentator. Number one would be Heavy Sigh. I'll allow it be number two. You're not wrong. Halsey OG, history lesson from Runkle? Yes, please. Miss Monty, thank you so much. Tracy Sires, could Proctor face prison time for all that's happened in this investigation and what may be coming up with other ones he was lead in? There is a possibility that Proctor ends up doing more time than Karen Reed. So there are no turtles on the Galapagos Island. You are wrong, sir. I saw turtles. There are sea turtles. There are also tortoises, but I definitely saw sea turtles. So, yeah. What is it? Goals are important. Goals are important. Happy Friday. Started running 3 weeks ago for the first time in my life. I lost 42 pounds this year and want to keep it going and get fitter. That is amazing. Massa Shenanigans, thank you for 10 gifted memberships. And PJ Wolfweimers, glad to be here. Glad to have you here as well. All right, so let me show you what my mom got me. And she got sort of the same thing, and yeah. All right. So first thing, she got me a hat. And the hat is ridiculous. Like, this is objectively a ridiculous hat. But let me show you what also goes with the hat that she got me. So, how do I get this to... This is hard to do when I'm doing it in a mirror. So... I didn't put that ear on very well. So I got one ear. I got the other ear. And then the hat. So she definitely meant for me to wear this on stream, because there's no way that she was intending me to not wear this on stream. But oh man. I was like, that is the silliest thing. And all right. Somebody says, no, leave them on. The ears. So because I'm also wearing the above the earpieces, the ears are hard to keep on when I'm also wearing the earpieces. So yeah, I suppose I could take them off, but yeah. Somebody says you should wear it to court. No, I shouldn't. Court will have opinions if I decide to wear that to court. The primary opinion being you don't get to wear hats. So yeah. All right. Now I'm seeing, what is it? Julia noting Monday we skipped the jury view that wasn't aired. Yeah, let's do that. We'll cover the jury view. So let me pull up the jury view. I don't want to skip anything, so we'll pull that up. And here we go. And page 90. All right. Whoop. Hopefully we haven't lost me. There we go. It was buffering for a second. All right. So we can look at the jury view if people like. And yeah. All right. If earrings are allowed, surely the elf ears are fine. Surely not. surely not. Yeah, that. And I should say, that's not the only thing Mrs. Runkle got, or sorry, Mama Runkle got me. But it is the funniest thing Mama Runkle got me. So Mama Runkle got me a couple of other things. So Mama Runkle sent us some money for basically to spend on Galapagos stuff. She's like, buy souvenirs with this. It's like, okay. So there was that. Mama Runkle also sent me a care package. And the care package is what is it? So there's these folks, the Just Rum from Just a Distillery Incorporated. They are in, I think they're in Oregon, but they're really good. And so I had a meetup in Vancouver, and they drove up and they like handed me some rum, and it's really good rum. I'm actually going to pour myself a little rum here. And I really like this rum. But of course I can't get it in Canada because Canada is kind of obnoxious. So it's difficult to get like U.S. booze products in Canada, and it's not just because of the tariff stuff. It's it's a big process. So small distillers, small producers have a hard time exporting to Canada. But anyway, they brought it up. It was lovely, and then they brought up a second batch, and so I Mrs. or Mama Runkle sent it to me. They have a souvenir shop on the Galapagos Islands. Yes. On one of the islands, there's like a whole town. And if you're in the town, it is like 75% souvenir shops. Because of course it is, right? And so there's lots of them. One of the things that's really interesting is there's a tree on the Galapagos Islands that is kind of a pest tree. And when I say it's a pest tree, I mean, somebody says, what's the brand's name again? So Just Rum from Just a Distillery Incorporated. But what do you call it? So this tree is the Spanish or Cuban cedar, and it was brought over by Norwegians. The Norwegians are the villains in this story, and the reason why the Norwegians brought this tree over was that this tree has nice wood, right? So they were like, we're going to grow these trees there, and they will produce this nice wood that we can use as furniture and so forth. The problem is that now it's invasive and it's growing and it's pushing out all sorts of things. So they want this tree gone. And what that means for the locals is that these, Spanish cedars, if you want to cut down a Spanish cedar, you're allowed, right? Any other trees you want to cut down, you have to get permission. You have to get all of this, stuff. But for the Spanish cedars, you want to cut one down, it's just, please cut some down, right? Thank you. Cut down some trees for us. So what that means is that a lot of the locals have like side souvenir businesses where they sell little wood carvings that are made out of Spanish cedar, because it's like, all right, please cut some down. They're like, okay, awesome. And so they cut them down and they carve them into nice little wood carvings. So you can get all sorts of wood carvings there, and it's all with this invasive tree that they want gone. And we have 7 minutes left on the goal for the Boxing Day story, which is also a story of Runkle has to spend more money because it's, yeah. All right. So The View. Mr. Lally says, good morning again, ladies and gentlemen. Again, as I stated in the courtroom, this is my opportunity to address you here. So some of the things that we talked about in there is what I would direct your attention to now. So you find yourself standing in a roadway. I would ask you to take note, sort of that roadway, of its length, both as you came in and as you exit at the close of all of this. But also I'd ask you to take note of the condition of that roadway, the width of that roadway. What, if anything, you observe as far as lanes within that roadway, both in the middle and sort of towards the side of the roadway. By the way, this is also how Lally does dirty talk. If anybody has the misfortune of sleeping with Lally, he's like, I would ask you to take note of the length, of the width. What, if anything? Yeah, all right. I would ask you to take note in different areas as far as where that roadway ends and where sort of other properties or residences begin, where you find that to be, and specifically as it pertains to a residence to your right. I would ask you to take note of distances from areas, um, as far as where we're standing now to where the driveway is, where we're standing now to where the house is, any doors or entrances, exits that you observe from that house, as well as anything else that you note as far as a landmark for some other or some sort of tangible objects that you observe within specifically the front area of the home and specifically the front to the left as you're facing the house in that area, the front lawn / yard area of that home. Mr. Jackson says, "Hi, ladies and gentlemen. Again, I would echo a lot of what Mr. Lally just said. We want you to get comfortable with the area surrounding the house, the roadway, the width of the roadway. I also want you to pay special attention, if you wouldn't mind. I suspect that was attention, but and note an area to the right of the flagpole. Its relationship to the fence, the gate, its relationship to a front door that appears in the middle of the house, and another door that appears just to the left. I would also ask that you pay special attention, if you can, to the area of the driveway and what ingress and egress, entrance and exits would look like at the front of the house, as well as any obstructions between those areas and the area adjacent to the flagpole here. I'd also ask you to take some note of the roadway and whether or not it's perfectly straight, whether or not you see a curvature on the roadway. Oh God, this is really, yeah. The width of the roadway, both from curb to curb, as well as the width of the roadway from the center line to curb, things of that nature. So now that we're on to Yanetti's, like, please also take note of the curvature. The last thing I'd ask you to pay attention to is simply the length of the area from the mailbox all the way up to an area that would be close to the natural property line, maybe here or beyond, the length as it pertains to vehicular traffic that may be parked. And that's about it. I think with that, that would satisfy us. Thank you. Thank you, Your Honor. Oh, and Your Honor, there's one other thing. There are a series of windows both on the bottom floor and the top floor. I'd ask you to pay special attention to the window on the top left of the home and its relationship to where you're standing, as well as the property area in front as well. Thank you. Thank you, Your Honor. And then discussion outside the hearing of jurors. Mr. Lally says, Your Honor, with the court's permission, what I would ask is to just give them a few minutes to do that, then take them over to the vehicle. Mr. Jackson pointed out that he would like to see inside the vehicle. It's just been a while since and the court says, open the door and see inside? Yes. Yes, ma'am. Just to look prior to the jury going over there. So with the court's permission, that's what we would. The court says, sure, where you asked them to look at the driveway, why don't we go beyond the car first to the driveway, and then we'll walk back to the car. And Mr. Unetti says, they can't see the mailbox. The court says, so well, if we can tell them that we'll walk past the car to the driveway and then come back to the car. Okay, we'll do that. And then Mr. Lally, so ladies and gentlemen, I by no way mean or shape or form mean to cut you short if you're still making observations or looking at things. But at this point, what I'm going to ask is for us to make our way down to the driveway just beyond the vehicle on the road, and then we'll make our way back to the vehicle after we've gone over to that area, okay? Pause. Mr. Lally says, oh, again, ladies and gentlemen, in this particular area, the same sort of general observations that I referenced before. The only other thing that I would add is that I would ask that you take note of again, where you find these things to be, but where you find sort of property lines to begin and property lines to end, sort of any natural observations that you make in reference to that structure, things of that nature, as well as similar to when we're on the other side of the property, now being sort of to the right as facing the residence as you walk, any sort of, man-made structures or landmarks, if you will, that you observe within and around sort of the area as well as the driveway area. So I wonder how the new homeowners felt about the court dropping a busload of people outside their house and told to look around outside their windows. I don't know. I suspect that they were probably looped in and, were probably told that this was happening. So, yeah. That sentence is sort of no less than 7 times. This is what happens when you're speaking off the cuff and transcription is being made, because you have no idea how many times you say, how many times you say, How many times? Transcripts make you look like an idiot. It's always the way things go. The things that you forgive in speech that you don't even hear in ordinary speech in a transcript make you sound or make you look like an idiot. It is the way it is. I hate reading my own transcripts because every every false start on a sentence, all of these things end up being as part of the transcript, and it'll drive you mad. It really will. So the court says, "Did you get that?" Court reporter, "No." Court, "All right, hold on, please. So, Ms. McLaughlin, you have to say that again. This needs to be recorded." Ms. McLaughlin says, "Inside the vehicle, counsel noted that there is a search warrant and business card of one of the troopers. We're going inside the vehicle to remove the search warrant and any law enforcement identification cards." Mr. Lawley says, "They should be marked for identification." The court says, "So the Commonwealth will take possession of this right now. Did you bring stickers?" Court reporter, "No, but that will be L for identification." Court says, "Okay." Ms. McLaughlin, "If I could just do a cursory look." So they wanted the jurors to look over the car, right? But before they look over the car, they're like, "We need to go and check. We need to go and have a look at the car. We need to have a look and see that everything is okay. It's been a while since we've seen the car." And so they go back and they check and they're like, "Oh yeah, there's a search warrant in it. Maybe the jury shouldn't see the search warrant," right? So yeah. Ms. McLaughlin says, "If I could just do a cursory look." Mr. Jackson says, "Of course." Court, "All right, so Ms. McLaughlin, I'll take that. And this is Madam Court Reporters. I'm going to put that on there." Mr. Unetti says, "May we take this and take it back?" Court says, "Trash? Timmy will take it." Court Officer Rose says, "That's my job." The court, "Do you want to close these doors and open them for them? Explain to them, Mr. Jackson, it's your request that we look in the car." Mr. Jackson says, "It's Mr. Lally request, but I have no objection." "All right, so why don't you just tell them what we're going to do?" So Mr. Lally says, "So ladies and gentlemen, if you want to come in just a little bit so I'm not screaming as much. Again, not to cut you short in any respect whatsoever as to any observations that you make or want to make with reference to this area, the house, or the one previous. So what I'm going to direct your attention or ask you to note at this point is with respect to a vehicle that is parked on the roadway behind you, okay? What I'm going to ask you to take note of with respect to that is, again, as I stated in the courtroom, the height of that vehicle, the width of that vehicle, the overall shape and size of that vehicle. In particular, I'm going to ask you to sort of walk around the exterior, paying close attention to sort of the height and width as you go around the vehicle. What I'm going to ask the court officer to do is open up the front door of that vehicle so that you can make observations in the driver's compartment of that vehicle, and in particularly anything that you may note sort of on the dashboard in between the driver's seat and the passenger seat, okay? You know what he's driving their attention to specifically? He's like, "I just want you to look in this specific area." What he's trying to draw their attention to is the rear view camera, right? That there's a backup camera. And so his argument here is there's a backup camera, so this can't have been an accident. Ms. Reed had to have intentionally run him down in the car that also had teeth to bite him. The car was it was a very bitey Lexus, right? So that's what he's trying to do. He's trying to say there's a rear view backup camera, so it was an intentional bitey car backing up, right? So thank you. And Mr. Jackson says, very briefly, also to dovetail into what Mr. Lally just suggested, the height and the width of the vehicle is obviously important. And I'd ask you to take note of the rear end of the vehicle, the bumper area, and the height, specifically of the tail light area on the vehicle, as well as when you're taking a look at the rest of the car. That's it. Pause. Court says, anything else from the defense? No, Your Honor. Anything else from the Commonwealth? No, Your Honor. Can I see counsel, please? So, yeah. Wasn't that removed from the car, though? The entertainment systems was completely gone. I don't know if it was gone at the first trial. I think it was still there. So yeah. We reached that goal. That goal was hit. We're good. So discussion on the outside the hearing of the juror court. How long are we going to stay? Mr. Lally says, I mean, I'm fine, but I don't want to interrupt them. Or court says, I don't want to interrupt them either. Mr. Unetti says, seems like at least a couple are still considering things. Mr. Lally says, I'd say probably 5-10 minutes or so at the most. That should cover it. Court says, I think as long as we stand here, they're going to stay here. Mr. Lally says, that's the other thing. But if you want, signal me when we should wrap it up and I'll start walking. Mr. Jackson says, about 10 minutes. You don't want to wrap things up. You don't want to push the jury here, right? You want the jury to, you don't want the jury to get, to feel like they're being rushed, to feel like they're being pushed. So, chief court officer says one particular juror wanted to know how far up the driveway she could go. Mr. Unetti said, I'm in touch with the homeowner. They gave us permission to go on the property. I can call and ask if a juror could go on the property if no one objects. This I thought was really interesting because the defense team got pictures from inside the house, right? And they wanted to tender those pictures. They were prevented from tendering those pictures. But Mr. Unetti was in touch with the homeowner. He's got permission for all sorts of things. The homeowner was like, yeah, I want to get to the bottom of this, right? Court says, I wish we'd known that before. And Mr. Unetti says, I didn't expect that we'd go on the property. Court says, I think we said nobody could go on the property when we started all of this. Mr. Lally says, I think it's safer to just go with that. Open it up on one end, then somebody else wants to do something else. Then they want to go in the house. What Mr. Lally definitely wants is them not going in the house. So, yeah. Is Jackson working on 2 cases? Question mark, question mark, question mark. Reed and Reiner. I can tell you, Jackson is not working on 2 cases. Jackson is probably working on more like 75 to 100 cases. Because nobody, he might be working on a few different famous cases, but you, as a defense lawyer, you're working on many, many cases at once. So, it's not like when you watch TV and they have defense counsel has the one case, right, that's going on. It's actually that they have many, many cases on the go. And, so, yeah. If you're looking for a new car, that Lexus is going to be auctioned off. First of all, that Lexus is going to go for way more than my budget. I can tell you that. And second of all, bringing a car from the US into Canada is a very, very big pain in the ass. And it's just not something I want to get into. What if the court dates have a conflict? They usually do scheduling such that things don't have a conflict. And so that, when you're booking a trial, you book it on days you don't have other trials booked, right? That's how that goes. So, yeah. I need to figure out another goal, but I don't have one in mind right this second. So, yeah. Court says, that's why I asked you all to work together on the view. We did. Okay. And then there's some sort of juror issue. It's a short one. There's no question or answer. What does counsel suggest? Our suggestion would be to tell the jurors that you're going to determine based on the testimony where the car was or wasn't. Okay, I'm guessing the jurors were asking, where was the car, right? It's here more for exhibit than specificity of Mr. Unetti says, it's placed randomly right now, correct? I think that would be the answer. Mr. Jackson says, they'll just have to wait on who testifies to where they saw it. Court says, I prefer not to comment at all on the evidence. We're here to stop and look. Those were my instructions. You're merely here to look. Mr. Jackson says, I have no problem with that, as long as they don't think it's specifically placed, because it's not. Mr. Nettie says, that was the question. So the jurors thought that the car might be placed in an evidentiary relevant kind of way, right? That it's, this was where the car was found or something like that. And the defense is like, let's correct that notion, right? I'm already planning my 2026 Halloween costume. I'm going to paint my arm blue, Garmin watch on the other arm, and a shirt that says Occiput Boner, and I'm going to throw myself at random cars. Leave the last part out. And yes, we'll do the Boxing Day story once we get through The View, which we're a few pages away. So, yeah. All right. The court says, I don't want to field questions because if there's one, there could be 15, and that's not the purpose of The View. What is the Commonwealth's position? Ms. McLaughlin says, I would just suggest what you propose, perhaps with a limiting instruction as to they are the fact finders, and they assess the weight and credibility through the evidence that will come out at trial. Mr. Yannetti says, I don't think there's any evidence to be evaluated with credibility when it's really the opposite. Court says, what I'm inclined to say is that the purpose of a view is for you folks to stop and look and observe what you're seeing, and you can use this as evidence in your deliberations. Just sort of what I said before. I think I'm inclined to also say no one can answer questions. Do you want the question part or no? I would like you to say that we're not allowed to answer questions. Mr. Lawley says, I think that's good. Okay. We'll bring them together behind the car, Your Honor. Sure. So the court says, so folks, the purpose of a view, as I told you before, first of all, the view is evidence. But what you are to do while we're here is to stop, look, observe your surroundings, and then later you can use this in your deliberations. It's not a time for questions or answers. I can't let you ask questions of counsel, and I can't answer any questions. So that is simply the purpose, and we appreciate how close attention you are all paying to this. Thank you. You can see my back is really hurting. Oh, yeah. So discussion outside hearing of jurors. Court says, counsel, please. Court and counsel gather. Do you think we should wrap it up? Mr. Jackson says, sure. Maybe ask them if there's any objection if we leave. Court says, I've never done that before. We decide when it's time. Jurors don't object. I'm not inclined to do that. I'll give them another few minutes. I think you're very fortunate that they're paying such close attention. I actually think the court's right here. I agree with I agree with Judge Canone in that, like, we tell you when we wrap, you guys don't get to run the show. Because if you start letting the jurors run the show, then yeah, it's kind of a thing there. So yeah. All right. Carrying on. Actually, counsel, it occurs to me that one of the jurors is pacing and measuring out pacing. It should have occurred to me earlier. They're also told that they're not to investigate, so that's pretty much investigation. So we're going to wrap it up. So court officer, all right, folks, we're going to head back to the bus. And that is the view. It's like, okay, we got to stop them. They're starting to do investigations. They've been given too much time. And yeah, they're starting to get clever. All right, let's review some super chats, and I'll tell you the Boxing Day story. Fiona W., thank you for 10 gifted memberships. Stepanova says, we love Mama Runkle. Mama Runkle is an absolutely amazing person. Love Mama Runkle's sense of humor. Me too. Mama Runkle is now the queen of fan service. That has a different meaning, so awesome gift from Mama Runkle. Lol. Yep. Happy New Year. Happy New Year. Against the Tide says, please like and watch Runkle's gaming channel. Also, Mama Runkle, you are the best. That was the best gift for his viewers ever from Tide. A Boxing Day story, please. I will. We shall watch it. B. Murr says, spend it wisely. Love the hat, Mama Runkle. I will spend it wisely. What, if any, Boxing Day story? Fair. Red Pen says, somebody had to be number 10. Awesome. Random unbreaded commenter. Too bad the new owners didn't have a great German Shepherd barking. Yeah. Happy Boxing Day. Happy Boxing Day. All right. So I don't know to what extent the US is a Boxing Day, like to what extent the US has Boxing Day. But Boxing Day is a big deal in Canada, sort of. And it's the day after Christmas, December 26th. And so the holiday historically comes about from like rich people being charitable in kind of dickish ways. So what Boxing Day was originally was a day when you would give a box to a to your underlings. So so if you are Ebenezer Scrooge and it's December 26th, and if you were like a kindlier person than Ebenezer Scrooge was, what you would do is you would go to Cratchit, your faithful assistant, and you would give him a box full of presents, maybe some cash. And it might also include one of the things they often used to do is like leftovers. And I mean, this used to be a big thing in like, Britain in like wealthy society. So they would have their big Christmas feast, the wealthy would, and then they'd pack up leftovers and give those to like their, to the help. And, you're like, yay, somebody else's leftovers. But it was actually a really big thing because, it was a big deal. Like you're getting to eat like the, like the wealthy do for that one day of the year. So Boxing Day was sort of a charitable holiday, but that's not really how it works in Canada. In Canada, Boxing Day has, for ages and ages and ages, has just been a shopping holiday. And so what that means is that Boxing Day, you go and the stores all have sales, and you go and you buy stuff. And so that's kind of the big that's kind of what Boxing Day is about. And at least in Canada. And nowadays there's a lot of like Boxing Week now is a big thing. So that's kind of how that goes. But yeah, it's a big deal. And yeah. So my personal Boxing Day sale or Boxing Day thing is that Mrs. Runkle and I need a new fridge. And the reason why we need a new fridge is that the what do you call it? How do I put this? The fridge and freezer doors no longer want to stay closed. They just want to swing wide open. And it's becoming a big problem because we're sitting there having to like tape the fridge shut, and if the tape gives way, then suddenly we've got stuff that's going bad, and all of this. So that's kind of the it's kind of the thing. But so we need a new fridge, and we're going off looking for a fridge. And the thing is this fridge is ancient. It's like super, super ancient. And yeah. So basically what I'm trying to do at this stage is, or trying to figure out, the fridge situation. Can't you just keep it outside in the Canadian winter? So we could use the fridge, like we could use outside as a freezer right now. if not for the fact that Zora would eat everything we put outside. But that'd be a whole thing. But yeah, it's so anyway, we got to buy one. And the other problem is that our fridge fits in like this very specific space in our house. Like there's this little cutout that the fridge slides into. And anyway, we're trying to figure out like that. It's an absolute nightmare. It's a whole headache. Yeah. It's we're trying to get that sorted out, and so I'm shopping for a new fridge. And the other problem, how much is a refrigerator? They vary vastly, but I don't want to get a Samsung and I don't want to get an LG because both the Samsung and the LG have how do I put this? Both the Samsung and the LG people have opinions about, and they are yeah, it's just miserable. So anyway, that's sort of the Boxing Day story. We went out, we had a very limited amount of patience, and we burned through it real fast. Sounds like you need new gaskets. We do need new gaskets, but we need a whole bunch of new everything. And like the fridge is just super old. The fridge is probably nope. I'm lying about that. The fridge is as old as like our marriage. So the fridge is at least 15 years old. It's older than that. So yeah, it's ancient. So get a commercial fridge. Can't, it's too small. The space that we have is too small. So yeah. I will have to look into that, but it's going to be a giant pain in the ass. So I'm not looking forward to it. But yeah, we ventured out to try to get a new fridge, and I was full of regret. And yeah, so all right. It's 30-inch wide, 66 inches tall. And the 66 inches tall is actually the problem. Because like when like most of them we find are like 67 inches too tall, or they're like 40 inches, and it's like shit. So yeah, and I want to get the least complicated fridge I possibly can. They're all the fridges now are like, we do Wi-Fi, we have a screen on the front, we have like all of the things, and I'm like, why? Who wants this? Like, who wants a fridge that we don't even want? So there's another fridge that we were looking at. It was looking like it would be a perfectly good fridge, and it has an ice maker. And so the salesman's there, and he's trying to sell us on this fridge, and he's like, and it's got an ice maker, and then we're like, oh well, we don't need that. We just we don't need an ice maker, so we're not going to connect that. And he goes, oh well, you have to connect it or else the fridge doesn't work. And I'm like, what do you mean that the fridge doesn't work? And he's like, the fridge doesn't activate unless the water line is connected. We don't have a water line where the fridge goes. We'd have to actually run a water line to the fridge. And I'm like, I don't want that. I don't want that. And he's like, yeah, no, you need a water line or else it doesn't work. And I'm like, oh shit. So yeah, I hate shopping for things. I hate all of this. So yeah. Hint on fridge, there are child lock Velcro products that will help you keep it closed while you research replacements. We have a solution right now. We have a solution for that right now. That solution is duct tape. We are duct taping the fridge and to keep it shut. So yeah. Donna J says, do you even need a fridge? It sounds like you always get takeout. We cook a lot. I end up getting takeout a lot on like days we're doing streams. But today, we had leftover ham, and that was ham I cooked for Christmas Eve dinner. And also, Mrs. Runkle made sweet potatoes, so it was good. All right, let's go on to the next day. So here we go. Oh. RE Pro Bono Fund, are you forever at YouTube's mercy in terms of monetization algorithm, or is there a solution to that? The solution would be venturing out into more platforms, but I'd be at YouTube's mercy. Any specific cash target? I don't have a specific cash target other than I need to be sort of, I need to be at a place where I can have 6 months of bad months and it won't cause me major problems. Right now, I mean, candidly, and I'm not trying to guilt anybody or anything like that. Candidly, revenue is on a downward slope right now, and that's fine. It's to be expected whenever a big trial ends. There's always a certain number of people who are like, Runkle, I was following you for the Karen Reed. And now I don't care because you're talking about like Canadian law or you're doing whatever else. And, so what do you call it? So that is that is kind of a thing there. But yeah, I don't know. I need to sort of plan for ups and downs. I would like to grow the channel a bit more before I make the jump, but we'll see. So yeah, we'll figure it out. I am still working on it. The other thing that I've got to figure out is what do you call it? I've got to figure out a little bit into what do you call it? What I'm hoping to do is I'm trying to so I mentioned before that like a regular caseload is something like 75 cases. And I'm figuring that if I'm doing this like YouTube full time and pro bono law, I'd probably be carrying something like 30 cases, not a huge caseload, right? Substantially less. Maybe lower, maybe 15 to 20. I don't know, right? But doing as much as I can pro bono while also doing the YouTube stuff and all of that. And I'd be doing a lower caseload in part because I'd want to do more appeals stuff. There's a lot of people who need appeals counsel who can't afford it. And the thing is that, what do you call it? Appeals, or just take a huge amount of work. But here's the thing. If I am going to hire an assistant, then my threshold for when I can go pro bono is significantly higher. And the reason why I say that is because, you got to pay an assistant and you got to pay an assistant a reasonable living wage. And, it's, that's a ton of money. So what I'm looking to do is I'm looking to go and find another law firm. And what I want to do is say, look, I'm going to take less. I'm going to take less, not a full caseload. I will take, I'm going to have a reduced caseload, like a quarter caseload or a half caseload. And so I want to use some of an assistant's time, not all of an assistant's time, but some of it. And what do you call it? What I'm hoping is to basically work at a firm as like I do my own thing, I do pro bono stuff, and that's it. And that's kind of the thing. And it's like I'll use some of an assistant's time, but also I will bring in some paying clients just by my existence here. That's kind of my hope, is to find a firm that will take me on that basis. So I got to work on that. So we'll see. I also have to figure out some things with the Law Society. One of the things with the Law Society is I got to figure out, ideally, a way that it doesn't cost full Law Society fees to exist, right? And yeah, essentially be at the firm for in-kind support and branding, pro bono kind of marketing, but you pay yourself otherwise. Exactly. I'm at the firm. They can use my name for advertising. They can do that. And I will help them out on files, where I can and so forth. But otherwise, they pay me zero. And I just, that's it. I don't collect a paycheck. I just exist in that space, and gives me a space to meet clients, gives me limited assistant use, gives me all of those things. Tide, I have thought about it. The problem is, kind of need people who can do local stuff. Things like, people who can make a courthouse run and that kind of thing, which is kind of difficult. But yeah, you're not wrong. So, all right, on to day 12. So we're not going to get through all of the sidebars today. We're going to get through some of the sidebars. We're going to go basically until my back says you are going to die. Because right now my shoulder, my back is killing me. And so we're going to go as long as I can manage, essentially, is where we're at. I am going to pull out. Somebody says, what about Runkle internships? So one day I will probably take articling students. And if I'm taking articling students, they are getting paid. And what I mean by that is that if I take on articling students, they are going to they're going to get paid a wage. And the way I'm going to work it, if I ever take on an articling student when I'm doing the pro bono thing, is basically the articling student bills. I don't bill, they bill. And what I mean by that is that the articling student does it as a, they get paid, like they actually bill for stuff. Now, the articling student will get a wage. It'll be whatever, whatever is fair, right? And that'll depend on what year this happens. Now, they bill, and the way it'll work is, like, let's say the articling student is making 75,000 Canadian, for the year or whatever, right? I'm just picking a number out of the air. I don't know if that's actually a reasonable number these days, but whatever. So they do paid work for clients. Like, clients pay for them. They take legal aid paid files, whatever they do. And they are not going to make enough to cover their paycheck. There just isn't, right? They won't. 100% they won't. But if by some miracle they do, if by some miracle they bill more than what they are making, which they shouldn't as an articling student, but if they do, then great. then they'll get paid what they build, right? So if they bill like 100,000, they'll get 100,000. If they bill, 50,000, then they'll get the 75 that was agreed on. So the only reason, but they shouldn't be doing that. That shouldn't happen because, as an articling student, you just, a lot of what you're doing is learning time and that kind of thing. But the reason why the articling student would be billing, the reason why the articling student would not be a pro bono articling student is one simple thing, which is I wouldn't be able to take them on as a fully paid lawyer afterwards. And so they'd need to go to another firm. They would have to be like working, articling for me with the plan of then going to work for someone else afterwards. And so what that means is that they need to be billing so that when they go to apply to another firm, they can say, look, I know how to bill. I know how to, I billed X much as an articling student, this kind of thing. So that's kind of the thought. But articling student is a further out project. It's not a right now project. Okay, back to the sidebars. But yeah, basically, I don't want any articling student I take on to be trashing their career by working for me. So, all right. So, on to day 12. And here we go. Let's see. So, Mr. Unetti says, yes, we've redacted them. The court can certainly take a look to make sure we complied. Court says, have you all agreed to the redactions? Mr. Lally says, we approached just as to that, Your Honor. Court says, yes. So Mr. Lally says, so, Your Honor, I'm a little confused, but Ms. Little grabbed me right before. First, I apologize for my tardiness this morning. Ms. Little had referenced to me just before the court came out that they'd blacked out something to do with TUI materials. I'm just a little confused on that. So here's the thing. You have to be, you got to be on time for trials. And usually on time for a trial like this is early. And the reason why it's early is so that you can have these discussions ahead of time with opposing counsel and with the court. So, yeah. And I'm running a little tens unit as we go here to try to, Court, okay, so I, and Mr. Unetti says, I'm not going to be showing these to the jury now if there's an issue with redaction. Court says, all right, they can come in later. Mr. Unetti says, well, I'd like them admitted now if I can, but subject to whatever redaction before the jury ever sees them. Court says, they will remain here. I'm not admitting them. I have some leeway on admitting exhibits. I actually agree with Judge Cannone here. And the reason why I say that I agree with Judge Cannone is that I wouldn't want to admit the exhibit and then redact it. I would be saying redact it first, and once the redactions are good, then I will admit it. But until then, I'm not admitting it. I'm on Judge Cannone's side on this one. Mr. Unetti says, of course, I know. And especially on cross-examination. I know. Court says, okay, so I'm not admitting them because we have to make sure all records are redacted. I have no doubt you'll be able to get them in, just not right now. Okay, so we'll mark this for identification. Whereupon key fob swipe records were entered and marked as Exhibit R for identification. So marked for identification, Your Honor. And Your Honor, I'm sorry. And the sidebar conference continues. All I wanted to say is I don't know where those came from because I don't recall that being in the material. Court says, okay, so let's get in with the evidence. We can discuss this. Well, I believe it's already in one of the exhibit books as far as the copies that I got from Canton PD and I provided to counsel. But I don't know where that came from. Court says, okay, so it's not in evidence. It's marked for identification. Thank you. It's like, all right, we're good, right? We're good. You're settled. You don't need to, you don't need to fight over this. All right. Next one up. So, what is it? The court, is there an objection? Yes, Your Honor. The objection is sustained. What is it? Mr. Unetti says, Your Honor, I would offer into evidence as full exhibits, both P and Q for identification, just the face sheet. Is there an objection? Yes, Your Honor. The objection is sustained. Can we approach? Okay. Can I see those, please, Sergeant? Yes. The judge is like, is there an exception? And, or is there an objection? And, yeah. Why would an articling student get $75,000? I just pulled that out of my head. I don't know what the current going rate is. Of Alberta articling students. So I don't know what their current. I'm just trying to look at what they're currently paying at the Crown's office. So at the Crown Prosecutor's office for an articling student, they are currently paying $78,408 for the year. And that is Canadian. So that is Canadian. 78,000 CAD to USD is so that works out to about 57,000 US. And the reason why you're paying that much is because these are articling students, are people who have already gone through law school. So, and they're doing like real legal work. So, yeah. So, Mr. Unetti says, I guess we'll hear the objection first. And the court says, go ahead with your objection. Mr. Lawley says, I don't see how any of this is relevant, number one. Number two, as far as it was already testified as to what it is. I don't understand why these need to be put in. And Mr. Unetti says, so this is going to be helpful to the jury. So what I'd like to do, and Your Honor, with regard to police reports, Your Honor is 100% correct. Typically, you don't admit somebody's police report with a narrative and all the hearsay that it contains. That's not what I'm looking to do here. And in fact, if the court only wanted to admit the top half of both of these forms, that would be fine. Court says, also, the no crime involved. There's a lot of hearsay. The court is a bit calling bullshit on Unetti. What Unetti is trying to do, or at least what the court is saying he's trying to do, is to tender the page that says no crime involved. And they're like, you can't do that. So there's a lot of hearsay. So what you want is the pictures, Mr. Unetti, right? That they're separate pictures. Mr. Unetti says, but I think it's far more powerful if the jury sees that the information is identical. And in fact, we can redact the no crime involved. I don't need that. The other stuff is just, I'm not offering it for the truth of the matter asserted. I'm offering it to show that it matches and what I think it doesn't match. That's why it's relevant. I'm like, yep. He's got to give it up when he's called on it. But yeah, I get it. I would have tried for it too. The court says, but he said he didn't know why this had 10. Says, no, he actually said that he did. That's the print date. Well, you said the print date, and he said, I guess. All right, printed by whom? The police station or you guys? No, not by us. This is a police document. So you just want these photos in to show that they're different? Mr. Unetti, yes, but I want to show that they're part of the police report. They're part of an identical police report. I mean, the fact that there is, the police logo and it all looks official. Of course, is all right. So I'll let it in, but I'm not going to allow you to publish anything on the screen because if this is indecipherable, Mr. Unetti says, well, we have ways of magnifying it. Court says, exactly. You can see it. Court says, maybe that's for a later time. I'll let you put in the top part after these are, but no crime involved because that would be hearsay. Right, yes. So he doesn't get the no crime involved part, which I absolutely would have wanted in his shoes, and I'm guessing he wanted. So, yeah. Court says, so I'll let you put in the top third of each of these reports as is, and later we can see if we can expand upon them. Mr. Unetti says, let me ask you this. Can we black out the no crime involved now with a magic marker and I can just show that? What the court has in your hand right there on a split screen? Court says no, because I haven't yet seen the altered version of this. And again, the jury gets the evidence right there. The jury doesn't get, I don't know. Have you seen what this is? Mr. Lally says yes. Mr. Yannetti says, I believe you may have it on your desk right now, but I gave the actual exhibit. Mr. Lally says, I don't know. Mr. Yannetti says, I thought I saw it. Do you have the actual exhibit? Jurors feel free to stand up and stretch. While Ms. Little is getting that, we need to still talk about Sergeant Lank and what exactly you intend to put in so that I can rule on exactly what I think. Mr. Yannetti says, of course. What you would be allowed to put in. Sure. Thank you, Ms. Little. Okay, is this in evidence? I hate to say this without any reference to it. Mr. Lally says, not that. Do you intend to put it into evidence? Mr. Lally says, yes. So with that, if you intend to put this still into evidence, Mr. Yannetti, if you could, and is this berm in evidence or, Mr. Lally says it is. Is this a different one? All right. So if you put that in first and then put these in, I'll let you put it on the screen. Mr. Yannetti says, okay, thank you. Court says, is there an objection to that, Mr. Lally? Mr. Lally says, I do have. And she says, to black out the, and to the photographs, no objection to that. As far as the report or any part of the report, there is an objection to that. If I was Lally, I would have objected to the magic marker. This is just a practice tip. Absolutely do not ever, on something that you cannot let the jury see, do not rely on magic marker as sufficient redaction. Ever. Because the number of things I have unredacted from magic marker is a lot. So, let's talk about how this works, right? You get a piece of paper and, you get this piece of paper and you magic marker it, right? There are a number of ways that you can pick that out. First of all, lots of the time people don't magic marker it enough, and so the text is just visible just by looking at it. That's number one, is failing to sufficiently magic marker it. You can often just see the text. Number two, the magic marker has a different reflective index or reflective whatever the fuck than the text. And so what that means is that if you get some magic marker redacted text and you hold it and with a light such that the light is reflecting off of it, you can often read the text as reflected text, right? The text will reflect, the magic marker won't. And so you just hold it up and, there you go. So that's number two method. Number three method is you put a strong light behind it, and often the printed text will absorb the light from behind much better than the magic marker will, and so you will see it. So that is not the correct way to make a redaction. What I do for redactions is I Sharpie the hell out of it and then photocopy it. And if you then go and you look at the photocopy, and you need to check the photocopy to make sure that the photocopy is itself not visible, right? You got to make sure that the redactions are done right. And I saw somebody in chat mentioned that there's a further problem with the way people do redactions, which is what they'll often do is they'll select a block of text and they'll just color that black. And the problem is that if you do that, then I might be able to go into Acrobat and remove that black block, or I might be able to go into Acrobat and select and then paste into another thing and see the text. If you actually use the redaction tool in Acrobat, it works out pretty well. But if you really want to be sure, if you absolutely want to be certain, redact it, print it, and then scan it again and you know that scan has no, has none of the data. Because, yeah. So if I'm Lally, I'm saying, no, I don't want it to be that. It's got to be redacted properly, right? So Mr. Lally says, as to the photographs, no objection to that. As far as the report or any part of the report, there is an objection to that. Court says, all right. So as to the top, what is your objection? He says, again, I think it comes into a bit of a dangerous territory in the sense that if counsel is going to try to suggest that there's some sort of difference between the reports, then I think we almost enter into a realm of the entire report coming in. Court says, I think he said he's going to suggest that the reports are identical. The only change is this. Mr. Unetti says, correct. So let's make that clear, okay? Mr. Unetti says, okay. So it's like, no, it's the opposite. It's the opposite, right? I'm not suggesting they're different. I'm suggesting they're the same. So the court says, all right, so the report is put on the screen. That has to be whited out, and only this part can be shown. Whiteout also is a bad redaction method, by the way, unless you photocopy it, because lots of the time text shines through the whiteout. The whiteout may have a different texture. And the other thing is that sometimes you can take a whited out document and just flake off the whiteout or abrade it off or whatever else and get to the text. So Mr. Unetti says, thank you. Court says, but you have to put that in first. Okay. Court says, your objection is noted, Mr. Lally. Ms. Little will give you that. Mr. Unetti says, Mr. Lally, I'm sorry. Just to make sure there are no mistakes, it's been suggested to me, and I think it's probably a good idea to cut this exhibit. Court says, okay. There's nothing else that's shown for sure when it's put on the screen. Wait, how are you putting it on the screen? I thought we already had it. I was going to suggest that Mr. Bates has the entire report. Because it's electronic, I don't want to take any chance to it accidentally to be put up. If we just cut it, we can use the Elmo. We've got an Elmo. Okay. Is that okay? Yes. So white it out and cut it. And just for the record, the P and Q exhibits are above the point where we would cut it anyway. Keep them on it because then that's when we'll put the exhibit number. Correct. Thank you. All right. So a lot of all of that and a lot of trimming and figuring all of that. So, all right. On to, so when my back is bad, I get muscle tension everywhere, like all sorts of places. And trying to unmess my back often requires dealing with things like, that my legs are messed up, that my arms are messed up, all of those things. So I've got the TENS unit right now on my leg, and it is like, every time it tenses, it's a really tense muscle, and it's giving me grief. So Mr. Lally says, yes, Your Honor, the Commonwealth calls Sergeant Michael Lank to the stand. Court says, all right, not yet. I'll see counsel at sidebar. So the court says, so we still need to deal with this. I assumed you'd want to know before you did your direct. Mr. Lally says, yes. So they've had all of this stuff like a voir dire as to what Lank can testify to and what he can't. And the court is like, we will decide what Lank can testify to and so forth. And what do you call it? And then Lally's like, and we're just calling Lank. And the court's like, no. That's not how this works. Like, you got to work this out. All right. And I got to set a new goal. What should the new goal be? New goal. Let's see. I don't have a good goal. All right. I'm not going to set a goal if I can't think of a goal, but yeah. All right. So the court said, you were saying before you had the officer available yesterday to go. Can you call him, or do I have to give this jury another break? And Mr. Yannetti, yes, Your Honor. I expect better from you than that. What was the issue there? Okay, this was the objection. She's giving him grief. All right. Now, despite the fact that he was charged, are you aware that the case was just flat out dismissed upon restitution in court? And Mr. Lally says, objection, move to strike, Your Honor. The objection is sustained. Jurors, you are to disregard that. The jurors, of course, are not going to disregard something that they've heard. Now, the problem is that this probably ventures into testimony as opposed to, and yeah. So, yeah, Mr. Yannetti says, I think it's admissible, Your Honor. The court says, I know you might, but it's not. Mr. Yannetti says, okay. Especially, we haven't had this conversation yet today about what I was admitting regarding that incident. So I'm just telling you that. Do you want to call the other witnesses, or do you want me to give the jury another break? Mr. Lally says, yes, I'm sorry. Ms. McLaughlin says, Your Honor, I just asked if I could step out to see if he's here. The court says, okay. I could step out of the courtroom, and the court says, sure. Whereupon Ms. McLaughlin steps from the sidebar and exits the courtroom. Mr. Jackson says, the court says, Mr. Jackson, do you want to tell me exactly, do you want to do this now here while the jury is waiting? Sure. Let me just grab I'm going to send the jurors out for 5 minutes. Mr. Jackson says, all right. And jurors, I'm sorry to do this to you. We're going to send you out back for about, why don't we take the morning break, okay? 15 minutes. So the jury is kicked out. And the court says, so I figure we should do this in open court. I know it's important to the defendant's case. So tell me exactly, based on voir dire yesterday, exactly what you hope to get into. So they want to get into Chris Albert. They want to get into all of those things. And yeah, we saw that in the trial. Hot sauce and rum goal. What about the puppers getting a treat? Here's the thing. Zora is right now very chunk. Very, very chunk. And Mrs. Runkle has kind of been like, hey, we got to do something about this, because she's gotten super portly. And our vet is going to yell at us when we next go in. The vet's going to be like, why is she so big? And so the Mrs. Runkle has been like, you cannot keep feeding her pizza crusts. You cannot keep feeding her treats. You cannot keep, all of these things. And yeah, so I probably shouldn't do a a treats thing. Does Zora like carrots as treats? No, she does not. No, she does not. Not at all. So yeah. All right. So, okay, where's our next sidebar here? So on to, many pages down. Okay, here we go. So clerk says, I just wanted to let the court know that we anticipate going into the relationship right off the bat. So if there's an instruction that the court, wait, that wouldn't be the clerk. That would be Jackson. Court says, with the whole incident right off the bat, Mr. Jackson says, correct, and get that out of the way. Court says, all right, thank you. Oh, wait. Where's the sidebar? Oh, yeah, that was the sidebar right there. So court says, jurors, so you're about to hear evidence of an event that happened in 2012. This evidence can be considered by you insofar as it demonstrates or relates to the credibility of this witness and the thoroughness of the investigation into this case for which the defendant is currently on trial before you folks. You may use this evidence to the extent that you find it credible in deciding whether or not there was any bias or favoritism on the part of the police in their investigation in this case. So, and that's asking Lank about the Albert family. All right. So, my dog loved ice cubes as treats, literally water. I got to spoil him with snacks. He got to regain his girlish figure in time for bikini season. Win-win. Zora does not eat ice. Does not eat like ice cubes. She might if I made them out of like stock or something. But yeah. What is that? Just. I had a dog who quickly swooped up a jalapeno that was dropped, ate it, and regretted it. Here's the thing. Zora likes spicy food. I have tried this with Zora. So at one point I was eating some chips, and these were really spicy chips, right? These were like extra spicy. And Zora was sitting there and she was begging, like begging. She's like, I want a chip. I want a chip. I want a chip. And I was like, Zora, you do not want these. You do not want these chips. I guarantee you, not something you want. And she was just like, oh, I want it so bad. I want it so bad. So finally, I'm like, all right, this is going to be a self-solving problem. So I give her one of the spicy chips. And Zora makes a face. She goes, and she makes this face of like, what is happening? But she doesn't spit out the chip. The chip stays in her mouth. She just makes this face. And I'm like, you see, Zora? And what does she do? She's like, I want another one. I want another chip. And I was like, you suck, dog. Like you just she's like, I want the spicy things. I have had moments where I had like hot sauce spill on the ground, and Zora will run up and like lick up the hot sauce. And some of those hot sauces are like a challenge. So Potter does not like spicy things, but she likes spicy things. All right. So they have Mr. Jackson saying, if we could fast forward to the 2840 mark or so, Mr. Bates, and play that. And let's pause it for a second. Your Honor, may we approach briefly? So they have a sidebar. Mr. Jackson says, I just wanted to briefly let you know so you don't become impatient. I'm going to play about 5 minutes of this and stop it at certain points. About 4 different points in the 5.5 minutes in total. You can tell Jackson is starting to lose a bit of patience with the court, because he's like, so you don't become impatient, because they've had moments where they're like playing something and the judge interrupts them and is like, how long is this? And he's like, it's one sentence. Yeah. So yeah. Court says, okay, just don't narrate it. I won't. Okay. So that's the sidebar. He's like, I'm just going to tell you, I'm going to play a few of this and, play a few minutes. And she's like, All right. On to the next one here. I think we're going to go through day 12, and then we're probably going to call a break or call a stop for today. We will probably do more on Monday because there's a lot of sidebars to get through, and I need like a hot bath. So, what is it? My favorite swoop is Potter holding his tagged elf, his eyebrows. Yes, let's. You can see it's still got the tags on it, because Potter is very gentle with his toys and does not brook any damage to his toys. All right. So, and where's our next thing here? It is 111. All right. So, they say, did you believe it that in your mind that it was possible, given the fact that a violent confrontation was possible in your mind, that it could have started inside the house? Mr. Lally says, objection. The court says, sustained. Mr. Jackson says, may we approach? And the court goes, yep. So, court says, what is the objection, Mr. Lally? Mr. Lally says, it calls for speculation. Mr. Jackson says, this goes directly to something. It's not asking him to speculate. I'm asking him what his state of mind at the time was. What did you conclude? The court says, you'll have to ask it differently. You were asking him to speculate. Ask it differently. Okay. May I? Sure. Lieutenant Lank, did you, given what you believed at the time and the possibility that there was a fight or whatever, did you logically think in your mind, your state of mind, was it possible it could have started in the house? And he said, if it had been a confrontation, it could have started anywhere. Right. The house is part of anywhere, right? Correct. This is part of how police testify, right? An ordinary person would say, yes, I thought it could have started in the house, or no, I didn't think it could have started in the house. And they're just like, and they will say, well, it could have started anywhere. Well, he's like, okay, if it could start anywhere, does that also include, like, does anywhere include the house? Is the house a part of the, overall sphere known as anywhere? And he's like, I guess, right? You can see how they sort of, fudge, right? And try to dodge and weave and so forth. And so he's pinning them to it. He's like, the house is part of anywhere, right? Correct. So in other words, the house is not excluded in your mind at that point, the starting point for the investigation. Is that right? And he's like, the starting point is that there was no indication he'd ever made it into the house. So, and he's like, but you didn't know that until you followed up on your investigation, correct? Yeah, you can see how the witness is trying to shape the evidence to get to where he wants it to be, and as opposed to just directly answering the questions. But that's police witnesses for you. That's how they roll. That is how they are. It is what it is. Okay. So they have here, they're talking about protocol for evidence sealing tape, and Mr. Lally says objection. Of course, says, do you know the answer to that? I don't. Okay, next question. Thank you. That's all I have for this. I'm going to see counsel at sidebar for just a minute, please. So court says, so I didn't want to interrupt you and embarrass you. You don't put anything up on that screen without my permission. You did it 5 times. Let's go to tab 1. Let's go to tab 2. Mr. Jackson says, I thought if it was in evidence, we were free to. And the court says, you don't just freely walk about the courtroom and put up displays. Mr. Jackson, where would you like me to? And the court says, Mr. Yannetti should have told you that. How would you like me to? What is the proper protocol to ask? You asked me for permission to put something up on the screen. Okay. Mr. Yannetti, you have a role with Pro Hoc Vice to let them know. I understand. All right, the jury needs a break. I've got about, just so the court knows, jurors, go ahead and let's take a 10-minute break, okay? And the sidebar continues. Ms. Little says the same question by a different witness in the same position yesterday. Just so the court knows, I have maybe 10 minutes left, no longer. And yours will be very short? Yes. Of course, says, all right, I'd really like to not bring him back again tomorrow. No. Will we start with another witness? I think we can probably get through with Lieutenant Ray. Yannetti says, I was going to suggest, Your Honor, that I would really like the court to rule on the photos I brought up at the start of the day yesterday, because I think there's a chance Caitlin Albert could be called tomorrow. Mr. Lally says, I doubt it. I doubt that. And Mr. Yannetti says, you doubt it? Court reporter says, I can't hear. Mr. Yannetti says, I just said that I was hoping for a ruling on the photos that I'd brought up at the start of the day yesterday. I do have further oral argument to make outside the presence of the jury. Court says, why don't you make it right now? He says, can I get my notes? Are there pages and pages, or is this? And he says, there's 3 pages, Judge. And the court says, Mr. Yannetti, I don't need to hear 3 pages of argument. You might, though. Like, this might actually be an issue that you need to hear argument on. Why are you denying him the right to argue? Mr. Yannetti says, here's the thing, all right? Let me just try to encapsulate it. I thought that it would be appropriate to discuss what orders have been in place regarding reciprocal discovery. This court is free to make any orders it wants at any time, and I recognize that. But I wanted to explain the reason why we didn't reveal the photos that were previously marked H, I, J, and K previously. And, it was our view that there was no specific reciprocal discovery order that required the provision to the Commonwealth of material that we deemed to be impeachment evidence. It would have been within this court's purview to order it. And as I said, the court can order it now if it has been ordered, if it has not been ordered to this date, and I recognize that. But that was the reason for that. So with regards to those 4 photos, I understand this court's ruling that those were inadmissible to use against Ms. McLaughlin. My position, our position, is that we are in a much different position with regard to Caitlin Albert. Not only with regard to those 4 photos, because now the Commonwealth is not surprised. They've had time to prepare her, and that topic of conversation would be part of our examination anyway. But also with regard particularly to these new photos that we just received over the weekend, there's been no discovery violation with regard to that. I have a list on my desk of all the discovery that the Commonwealth has provided to us that continues to come in on a daily basis since this trial has started. And for all the shit that Judge Cannone was giving to the defense for disclosure violations and discovery violations and so forth, she was just peachy with the Commonwealth not just providing stuff midway through trial, but also providing stuff after the trial, because there was plenty of stuff that came in post-trial that that we didn't find out until trial 2. There was additionally stuff that came in even after trial number 2. Even after trial number 2, we find there was additional stuff that was not, disclosed, and, additional Proctor bullshit, additional all of this. It appeared like this is just messed up. So, I'm just going to start a hot sauce goal here. All right. So, clearly this is not something that we held back. It's new. It's relevant. And, the court had indicated yesterday that, it may become or may be cumulative. I take issue with that because there's been no photo introduced of their relationship. And there's been an attempt by Ms. McLaughlin to minimize that relationship. These photos not only prove that she was minimizing it, but in my view, proof that she was lying on the stand about the nature of the relationship. She had said specifically 2 things. Number 1, that she hadn't had any contact with Caitlin Albert in the last 2 or 3 years. Come to find out, we have a photo from 8 months prior to January of 2022, where there's a limited number of people in a photograph, and Caitlin Albert and Katie McLaughlin had their arms around each other at a baby shower. In addition, Liza, what was the statement? Oh, yeah. She had also said that they only take day trips together to the beach in a group. We have a photo of them in Maine, 4 hours away, drinking in a hot tub, which clearly is not just a one-day trip. And then we have photos with the 4 of them together where she is with Caitlin Albert's 2 college roommates. So there's Caitlin Albert and her 2 roommates and Katie McLaughlin. She started off her testimony by saying, I went to school with somebody by that name. I am like, this is insane. It is insane the amount of stuff that they were, and that Judge Cannone was not like, oh, this witness is lying. Go to town. Because usually my experience is that if you've got a witness who the court knows lied under oath about something, usually the court will absolutely let you savage them. And what I mean by that is that the court will be like, Mr. Runkle, it is go time. Like, they will just be like, go to town. Like, kill this witness for me. Like, not literally, but. And I had a case where I had the witness dead to rights on lying, dead to rights. And I was taking my time, right? I was just like, peeling a piece off. And I was just like, we're just going to get the little knives and we're going to cut you to ribbons. And the Crown objected. And it was clearly an objection to like buy the witness some time. And the judge said, Mr. So-and-so, you are not to object again unless your objection is valid. And I was like, yeah. Because the judge is like, you do not get to save this witness. This witness is gonna burn. And it's the witness's own fault. It was just like, Mr. like Crown prosecutor, I will not hear another objection from you unless it is a valid, grounded objection. And it was just like, sit down, let him cook. And I tore that witness to shit. Tore that witness to absolute shit. And then the judge was like, Crown, any thoughts? And the Crown is like, Crown would like to withdraw. And the judge is like, well done, Crown. Excellent. Your star witness just got ripped to shit. So, yep. Judges do not like witnesses who lie to them. Judges do not like liars in their court. Usually when a judge has the notion that a witness is lying intentionally in their court, the judge wants them to have a real bad day. And yeah. So it is what it is. So they dropped the case. The Crown called no further evidence and invited dismissal of the case, which is not quite drop the case, because it's not the same that it's withdrawn. It is that when the Crown invites dismissal like that, in Canada, that attaches the double jeopardy and says, okay, they cannot bring this case back. It's over. It's done. So, and they say, she started off her testimony by saying, I went to school with somebody by that name. That's like saying, I know somebody who raised me who happens to be a woman and is married to my father. Yannetti, love it. Love this line. If I get Yannetti back on the channel, I'm going to have to ask him about this line because it's freaking funny. She misrepresented the relationship. This is central cross-examination material, and these exhibits are relevant. There's been no discovery violation, and I seek to use them during their cross of Caitlin Albert. And the court says, what do you say? Mr. Lally says, Your Honor, what I would say is there absolutely has been a discovery violation. The Commonwealth filed a motion for reciprocal discovery, which the court, I don't know if it was acted on as far as writing on the order, but it was specifically stated to counsel to provide those. The subsequent absolutely do nothing to further any point as far as firefighter McLaughlin. And I remind counsel that it is a firefighter, and that's how she's involved in this case and comes to the scene in the first place. Who cares? She's a witness. If she's lying, then yeah. Frankly, the cross-examination, I'm going to leave it at that because I don't want to say something that I may regret. If you're into the territory of I don't want to say something that I may regret, back the fuck up further than this, Lolly. But with regard to most of this is cumulative. The other sort of photographs that are in here are, they went to high school at the same time, which firefighter McLaughlin acknowledged. They were on the same track team. So were about 40 other people. Every other photograph that's contained in here is in a group setting, which is what firefighter McLaughlin acknowledged. There's absolutely no evidence whatsoever of any prevarication, any lying, anything mentioned in front of this court and flat out accused firefighter McLaughlin of doing. There's no evidence of that in those photographs, the other photographs, or anything about her testimony. And frankly, it's repulsive. And the court says, all right, so I'm going to strike the repulsive part. If I was the court, I would be like, Mr. Lally, you need to dial your tone back because it is not inappropriate for defense counsel to suggest that a witness might be lying. It is, in fact, often their ethical obligation. Do not call defense counsel acting within the scope of defense counsel, like whatever, repulsive. Go fuck yourself, Lolly. And I will happily send you a broken bottle to do it with. Like, Cleopatra says, I'm in and out of the chat and I want to know what Uncle Runkle is drinking. Uncle Runkle is drinking just rum out of, I believe it's Sandy, Oregon. So, yeah, it's very tasty. Yeah, Lolly, repulsive? Are you fucking kidding me? Of course, it's all right. So I did find that there was a violation of Rule 14. I know that counsel said that you didn't intend to use it, but I disagree, and I find that you did. So I'll mark all of these for identification. There are 7 of them, and I made an independent finding that they are cumulative, that Mr. Jackson got the answers he was looking for, and that the photos are not inconsistent. So for all of those reasons, the photos from the other day are out, and these are out. Mr. Unetti says, specifically, with regard to these, the court says, hold on, I'm sorry. Do you want them as one, or the court says, I think one is easier. With regard to the, hold on, I'm sorry. And the court says, all right, what's your question, Mr. Unetti? Just so I understand the court's ruling, with regards to these additional photos that we received over the weekend, is the court's ruling that they are excluded in part because they too are a discovery violation? Court says, I don't know where they came from or who authenticates them. Did you get these, Commonwealth? Mr. Lally says, I mean, when the court did. Mr. Unetti says, I had represented that we received these over the weekend, and in fact, we got, court says, unknown sources. Right. And some are marked. Tori, can I have that, please? Thank you. So I don't hear anything right now that would make these admissible. No, because they have to ask the questions that make them admissible. They should be able to ask the witness, do you recognize this picture? Do you, like... The court's like, these have not been authenticated yet. You authenticate them with the witness who's right there. Like, you just say, defense counsel, you're going to have to authenticate these. They're from a mystery source. What's your plan if they say, I've never seen these before? Right? So, yeah. So you need to question the witness first. That's what they want to do. I don't have your discovery motion in front of me, Mr. Lally. Did it include impeachment material? Mr. Unetti says, I can speak to that because I reviewed it. It did. If that motion was allowed, then my reading of the motion is that these, not these, but the previous 4 photographs should have been turned over. But I also, the court says, okay, the motion was allowed because I remember saying I knew you had to wait until a certificate of compliance. Right. And I said that the Commonwealth's motion is allowed, is my understanding, and you had to get it immediately. And I think I said 2 days. I didn't even know that Ms. Little complied much sooner than that. Right. And I'd rather handle it in his testimony. Do you need much more time on this hearing from all three? Actually, just the two of you? Mr. Unetti, well, I was just going to explain, Your Honor, that I checked the docket. The motion was not endorsed, but I don't question what the court just said. Okay, I remember specifically. Okay, the 2-day part. That's fine. Why don't we just continue? If you come up with another argument before the witness testifies, you can tell me about it. Okay, thank you. I really don't want to waste any more time. I understand. So we won't get a break. We'll just bring the jury in, okay? Fine. Yeah, all they needed was for her to sit and squirm and get defensive and start over-explaining. There's nothing you have to do with the foundation of the photos then. I mean, the thing is, and usually the witness will identify the photos, right? You know, hey, here's the photo. Do you recognize this? Oh, yeah, that's from my Facebook. But, you know, that happens all the time. All the time. Like the number of times I have gotten in somebody's Facebook page by showing them the pictures from their Facebook page is like a lot, right? And I might have a witness to get in their Facebook page. I might have a witness that I can call and be like, the sole thing this witness is going to say is, I browsed to this person's Facebook page, which was publicly visible, and I downloaded these pictures, right? And I saved these screenshots or whatever. But usually you don't need them. Usually when you show somebody that picture, they say, yeah, that's from my Facebook. And in fact, usually what I do is I don't show them the showstopper pictures first. What I usually do is I show them like their Facebook page and like have it pulled up to something like a picture or, you know, a post of them going, you know, hey, we just got a new puppy or something innocuous like that, right? Because, and the reason why I do that is because then the witness, you know, will say, yeah, that's my Facebook page, because they don't see anything wrong with saying it's their Facebook page because it's just the cute puppy. Right. And they're like, yeah, that's when I got a puppy. And you're like, oh, now is this also you lying to the court? You know, like, oh, the puppy is great. And yeah. So, I mean, I had a case where I walked in and I had about, I think it was like 300 voicemails that this complainant had left my client. And in the 300 voicemails, I had to listen through those voicemails to something like voicemail number 140 to find one where the complainant sounded like a human being and didn't sound like a freaking psycho, right? It was just a very boring message. It was just like, hi, I miss you. Can you call me? Bye, click, right? And I had to listen to like 140 messages because you know, it took that many messages to find one where she actually sounded like a sane person. And that was the message I played first. Play that message. And then, okay, is that your voice? Is that you on this voicemail? Yes. You left that voicemail? Yes, I did. Okay, now we're going to start playing the crazy ones. And then the person is very much in having a difficult time saying, well, that's not me on that recording, because you just heard the voice, right? You just heard them say the other voice was them, and it's the same freaking voice. And yeah, so anyway, I am ranting. All right. So they're asking, and the same thing when you went back on the third occasion, what, if anything, did you note as far as the interior of the house? Anything askew? Anything out of place? No, everything looked to be in order. Nothing further, Your Honor. And Mr. Jackson says, may we approach very briefly? Yes. And Mr. Jackson says, Your Honor, the court's order to me, to the defense, was that we were not to get into the specifics of the actual fight, which I closely guarded against, and I did not. Mr. Lally just did exactly what the court ordered me not to do. He said, tell us what happened involving this fight, giving him the detail of how he was punched first. He was attacked first. There was foul language used. There were threats used, and all he did was defend himself. With the court's permission, I intend to ask 3 questions. Number 1, you just described a situation in which 2 men assaulted a police officer, basically in front of other police officers. They were never convicted of anything. I won't go into it any further, but I'd like to say they were not convicted. Mr. Lally has indicated that they were charged, but I think the other side of the coin is but they weren't convicted. The second thing I'd like to ask is he made a statement saying, whoever you are, I'm going to make your life miserable. And that's on record. He didn't admit or deny it. And then the third thing is simply wrapping it up with this was in furtherance of you coming to Chris Albert's aid. And the court says, all right, how do you respond, Mr. Lally? And Mr. Lally says, Your Honor, as it pertains to, I didn't have any indication. There was no indication that anybody was arrested, charged, or anything as it pertains to Los Pilatos. So whatever happened with the case is not relevant and germane. Except you already got it into testimony. You already got it out. If you're saying it's not relevant and germane, why did you ask for it? As far as what I did with the witness was in response to Mr. Jackson's questions, which understandably on cross-examination, they can be leading, but essentially led them through a certain narrative that I did not believe to be accurate. And so I asked the witness what his recollection of that narrative is. That has nothing to do with any of the subsequent trial intimidation charges or anything of that like. I think as far as his, and I'm sorry, I can't recall exactly what your questions were again. The main thing that I'd need the court's guidance on or alert the court is I want to be able to ask him, given the narrative that he just described from Mr. Lally, anybody would expect that he would have been charged and convicted. I simply want to be clear they were not convicted of anything, which suggests this narrative is spinning the facts in his favor. Court says, so tell me the question again. I don't want 5 questions. You said there were 3 questions. I don't want 5 on the same topic. Right? It's like, this feels like the holy hand grenade. Count to 3. 1, 2, 5 is definitely out. So, yeah. Right. The court says, what is the first question? You claimed in Mr. Lally's questions, you claimed that you were specifically physically assaulted by, the fact of the matter is they were never convicted of anything having to do with assault on a police officer. What was the second question? You indicated that they said to you, and I will adopt my language accordingly, I don't give an F what we do. I'm going to continue to fight you anyway. On record, what was said was he said to them, I don't know who you are, but I'm going to make your life miserable. Court says, all right, so let me hear the first question again. I thought the first time he said something like this happened in front of several police officers. Right, your claim is that you were assaulted in front of other police officers. They were never convicted of anything having to do with assault on a police officer or anything else regarding this incident. Yes. Court says, I'm going to allow it, Mr. Lally, and I feel bad. The court's like, I'm going to give one to the defense, and I feel bad about it. But okay, she's giving it to the defense. It's the one time he did not really ask any leading questions, and all of this came in. So I'll allow the in front of police, the first time you worded it was the best. Okay. I don't want you to get into all the details that Mr. Lally, just in response to Mr. Lally's question. Right. And the second one was, you actually said to them, I'm going to make your life miserable. The court says, okay, all right. I'm going to allow it. And Mr. Jackson says, may I, Your Honor? Yes, very briefly. Jackson wins that objection. He gets to go exactly where he wanted to go. And, but she was super sad about it. She's like, I feel bad. I feel bad that I got to give the defense one, but, I'm going to allow it. And so the last sidebar is just scheduling stuff. I don't know if we need to sort of cover that. What is it? They pause, and then they have a sidebar conference. They just say for scheduling, they have a few more minutes this video, than the ring videos. And then they say he's going to come back tomorrow. They're going to break. And that's the sidebar. So, yeah. And this is a good thing. Oh my God, lady, you don't get to have feelings while wearing the black robe. That's exactly it. You allow it or you disallow it. You don't feel bad about it, right? You allow it because the law says you have to allow it. You disallow it because the law says it's not allowed. That's how this works. Your feelings should be purely just, I do law here. That's it. So, Jolene Loves Cats says, Fridge Fund, thank you. Atticus Matlock, thank you for the YouTube membership. B. Murr, thank you for becoming a member. That Bosnian chick says 5-pack of fridge child safety lock for $8 on Amazon. Yeah. The thing is, there's a lot of things failing there. So, yeah. Door seals for refrigerators are much less expensive than a new fridge. Also true. I don't know. Maybe I'll have to look into that. If your lawyer gives bad advice, like it's fine to destroy that evidence, does my lawyer said it was fine protect you at all? It depends on the statute. Some statutes have things where it's allowed. Some things have statutes where it's not allowed. So, yeah. So that is the end of day 12. I think we're going to call it here because I am going to pour the world's hottest bath and see if I can whatever this is. There's like one muscle like cluster or something in there that's just absolutely knotted, and it's absolutely wrecking my back. So I think we'll wrap it here. We've been going for nearly 3 hours. I'm thinking we'll do another one on Monday. And I'm just trying to see here. What day is Monday? Monday is the 29th. So I think we'll do another one on Monday. That'll probably be our last stream of the year, but we'll do one. And go from there. So thank you guys all for joining me. I really appreciate it. I got to also spend some time. I got to get the calendar done. I'm running out of days for that. So I got to get that done. I also have to, I want to edit some of the like videos and pictures and so forth down into like swoops and little whatever. So I want to share some of that. So, yeah. Anyway, thank you guys all for watching. I hope you found this to be interesting and educational and all of those good things. And yeah, I'm just going to go try to unmess my back. So I will see you guys later. Are you going to add animal pics from your vacation to the calendar? There are animal pics from the vacation in the calendar. I don't think I appear in the calendar at all. So, all right. Good night, all.